we last spoke, E&P had done an announcement that they had raised money from the ECOWAS Bank to buy the assets. And I was suggesting that because they are in dispute with the owners of the asset, and we'll come back to this issue around ownership, they couldn't have acquired it without the participation of the owners. What has happened since then, and what is quite alarming, is that E&P has proceeded to transfer the shares of the company to themselves. And that is the alarming part of things, which is to say that as a negotiation tactic, they've left the owners almost with no choice than to walk away. And I think what they are trying to do is to ensure that the owners will take the lowest price possible for the asset. And that is why this is a public interest issue, because let's not mince words about this. The 100% shareholder of E&P is a very, very prominent politician in this country. It's one of the most formidable politicians in this country. In that respect alone, if politically connected people are able to use this kind of strong arm tactics when involved in a commercial transaction, it has the effect of damaging the investment climate. Because if you're an investor and you worry that if there's an incident and somehow you come into conflict with someone that's politically connected, they can take actions that ordinarily other businesses will have great restraint or reluctance taking because they will be confronted by the law enforcement authorities and the other authorities. So that is really where we are. What happened is that, and it's a very convoluted matter, and therefore one risks the prospect of providing so much information that people get confused. But I'll do my best to try and break down the core issues. First, there's a public interest not only because the 100% shareholder of E&P, Engineers and Planners, is a very prominent politician in this country and is indeed the sibling of the certain president. It's also the fact that mining is a unique industry because government always has shares in every mine. This is not the case in hotels or other sectors, or even other regulated sectors like banking, etc. The second reason is also that mining typically is intertwined with conflict and environmental damage. We all know the Galamsey issues and the rest of it. So globally, we've set up a regime, and that regime requires civil society to be part of the arrangements in relation to mining. We call it the Extractive Industries Transparency Initiative, which is why someone like myself is deeply involved in a matter like this, because I think the sunlight, publicizing the matters are necessary. Anyway, to explain this whole situation, we need to go back to some of the key points I made last time, right, around the ownership, etc. It is true that the main deposits in this gold mine, there are two gold mines we are talking about. I'll focus primarily on Black Volta because the Sankofa gold mine is not well developed. Black Volta is maybe 90% of the value of what we are discussing. The Black Volta itself is multiple deposits. In fact, one of the deposits, Julie, was acquired later and added to the mine much later. The original people who discovered the resource, the main resource, which is called Kunche, are not even involved in the picture at all because that was as far back as 1998. Those people then sold it on to a group led by a gentleman called David Harper, who is still in this country, that attempted to develop this Kunche resource by raising money in Australia in 2006, between 2005 and 2006. So what that means, therefore, is that for a very long time, the assets that we are talking about here was owned by a different group of people. It was only in 2017, when that group of people ran out of money, that this set of current owners, which is Ibaira, came into the picture. This is 2017. And they only acquired full ownership in 2020. So there's a lot of discussion around whether they've been sitting on the assets since 1992, and it's not correct. I'm just giving you the correct picture. It's also true that the mining lease does not date from 1992. The mining lease actually dates from 2014, and it's just a 15-year lease. So it's not one of those 30-year leases, etc. So it's a 15-year lease, and that 15-year lease expires in 2029. So there are two leases there. There's Bepon and there's Kunche. All of this to explain that when people suggest that somebody was sitting on the resource without developing it is not correct. The next set of facts is that the current investors, which is Ibaira, had invested in this Azumah Ghana prospect through a set of special purpose vehicles. There is one called IGIC, which is incorporated in Singapore. And there is the original Azumah in Australia, which they had acquired on the stock market. So the Azumah Ghana is owned primarily by IGIC and Azumah Australia. And IGIC also owns Azumah Australia. So when you combine, IGIC essentially owns 100% of the company, the Azumah Ghana. IGIC is just a fund of Ibaira. Remember that for tax reasons, typically the actual transacting medium, the vehicle that is doing the investment and things like that, could be put in another jurisdiction from where the fund itself is domiciled.
Okay.
So in the case of Ibaira, because of tax reasons or other reasons, they decided that the company that will buy the entity in Ghana and in Australia will be based in Singapore, which is the IGIC. So essentially, Ibaira, as a private equity fund, owns all of Azumah Ghana. There's no dispute whatsoever about it. There are 4 partners in Ibaira, one of which is the James Moore Bank that you keep hearing about, another is the John Honsky, and there are 2 others. And those 4 partners, of those 4, 2 sit on the board of Azumah Ghana. So that's also another important point to clarify. The third critical point to clarify is that in 2023, when there was an agreement between IGIC, Azumah Ghana, Azumah Australia, etc., with E&P, engineers and planners, all those who were signing on the other side from engineers and planners were controlled essentially by Ibaira. There's no doubt and dispute about that as well. And I have all the documents here, which I'm happy to show to your viewers. So in essence, engineers and planners have always known that they are dealing with Ibaira, and that the key partners of Ibaira, led by James Moore Bank, are the owners of the assets. There's never been any doubt. They are currently negotiating to conclude the transaction. And I'll come to that in a minute. And the people on the other side, which is essentially Azumah Australia and IGIC, are controlled by Ibaira. And E&P knows that because it's in continuous negotiation with them. The 4th point, which is equally critical, is that when the agreement between E&P and Azumah, the Azumah entities, which is essentially Ibaira, were consummated in 2023, it was very clear from reading the agreement. We've had international legal experts read the agreement thoroughly to confirm our understanding, whether our understanding of the agreement is correct. It is very clear that the nature of the agreement was not sell and walk away. The nature of the agreement was a framework for acquisition and development together. And that framework required first and foremost E&P to pay some amount of money, $50 million plus another $50 million, as a right to participation, but it also required them to build the mine over time, because the $100 million was only for the issue shares, and they were supposed to have more shares vested in them as they developed the mine. So there was never a case of we are selling the mine for $100 million, pay them $100 million and walk away kind of scenario. It was always a marriage, a strategic marriage to develop the mine together. The 5th point is that ultimately, the way that the parties understood the agreement appeared to differ. For instance, when E&P brought a potential offer from the ECOWAS Bank to the table, the other guys felt that that offer did not meet the terms of the agreement. I'll give you a couple of examples. One, there was a belief that the $130 million that the ECOWAS Bank is offering is not enough to cover the needs of the project, because the bankability feasibility study suggested that the estimated $150 to $160 million was not enough.
So when they rejected that, they came a second time with another term sheet.
And that still did not reach the over $200 million that, in the view of Ibaira, the bankability feasibility studies suggested is needed. And the understanding of the agreement was that you will raise whatever is needed. E&P obviously had a different view. But whatever be the case, those are the two trying to get into a meeting of minds. So what happened then is that they then also looked at the terms and realized that it was indicative. It was for discussion purposes. And therefore, it's not a firm offer. And they rejected it. A second one, they rejected it. Another attempt through Afrexim Bank, which was another offer, was also not accepted. Those details are before an arbitral panel before E&P withdrew the matter. But my point is that there was no meeting of minds. Because there was no meeting of minds, at some point, Ibaira, which controls the entities that own this Ghana entity, the Azumah Ghana, terminated agreement. And when you look at the termination agreement, which I'll also show very soon, you will see that all the people that signed are the very people that E&P entered into the agreement with. So if you think of Kangol, which is another special purpose vehicle, the person that was responsible for Kangol signed. If you think of Azumah Resources, John Ronsley's kind, and what's his name? James Warbank also signed. So in effect, there was a termination that E&P disputes. Now before that, E&P had already gone to arbitration. But who did E&P take to arbitration? A group of companies, all of whom are ultimately controlled by Ibaira. Now, in the course of that, E&P then proposed to hold this event, which I had gotten wind of because I'm in E&P's affairs because we are in court, right? So I then...
At the time, E&P had been successful in the local court in securing an injunction against...
Yes, an injunction to prevent the sale of the asset or any kind of investment coming into the asset that does not come through E&P.
Correct.
Essentially, but if you read the judgment of the High Court judge, it was very clear that she was freezing action on both sides, and we will display that also for viewers to see. If you read the phrasing that the judge used, so that effectively meant, therefore, that in a way things were in a standstill. Then, when this event was held, which brought this whole matter to the limelight, we suggested that event was not proper because the other persons who owned the asset were not party to the agreements, and that was confirmed by Azumah. This recent incident involved the transfer of shares by an individual purporting to be the beneficial owner to E&P. To our minds, or in our minds, that individual is not truly the beneficial owner in that sense of the word because he doesn't really own the shares.
And that was the most important question I was going to ask you after you said that E&P is transferring these shares onto itself. When we see, even in the pictures that we have seen in the course of the week, where these processes are happening and there's a signing, as you see them on the TV, Azumah Resources was represented. But now what you are saying is that the person purporting to represent Azumah Resources is somebody else.
Okay, so this person that you see, this gentleman in the middle, this Caucasian gentleman in the middle, has actually nothing to do with Azumah Resources. If my understanding is correct, this is somebody who is linked to Caterpillar or one of the vendors that provide equipment to E&P. But E&P's representative here will explain if this person is any of the Ibaira or other owners. So the key principles are very straightforward. The person who was listed as the beneficial owner is a gentleman called Hector Ninaku. Hector is the secretary. He's an inherited employee of E&P in that he was in the company before, inherited employee of Azumah Ghana Resources, because he was in the company before this group, these new owners of Azumah, came to play. Are you understanding what I'm saying? So you remember that this company has been around for a while, and these people bought into the company. Okay. So when they bought into the company, Hector Ninakun was already the administration manager of the company. So they inherited him. Now he was, because of the fact that he was the administration manager.
Saying that these people who are at this signing, there's a signing, they're all happy. There's some deception.
No, I'm saying that this white man has nothing to do with Azumah in any way. This is a Caterpillar or some vendor, who provides equipment to E&P. You have to remember that we are dealing with a think tank, right? So there's nothing we'll say that we haven't exhaustively kind of, and remember, people assume that we have an interest. We really don't have an interest. We are interested in transparency.
Right.
Yeah.